Tomorrow at 9:30?
You had said if we had any pre-trial motions to bring those up.
Yes.
All right, Judge. So I had filed a motion.
Kicking off with high tension, the defense drops a bold move, demanding YouTube broadcasts be stopped. They claim it threatens the defendant's right to a fair trial, but is that justice, or just drama dressed in legal robes?
August motion to prohibit the YouTube broadcast of all the legal proceedings.
And I don't have that motion. It's not in the court's file. We're going to have parties announced for the record for the state.
Anna Ochoa Nelson.
Defense.
Alex Scharf for Mr. Dillard.
All right, defense, your first motion.
Yes, Judge. The first motion is the motion to prohibit the YouTube broadcast of all legal proceedings in Mr. Dillard's case. The basis for that is that he's got a constitutional right to a fair trial. And by broadcasting what happens during the trial sets up great room for error to happen. As you're aware, the court previously had a trial where one of the witnesses, the complainant, admitted to watching the YouTube testimony of at least another witness.
And you do realize that that complainant testified first, correct?
Yes.
Now here's the real twist. In a past case, a key witness watched someone else's testimony on YouTube. That's every defense attorney's nightmare, because one click like that can wreck the entire fairness of a trial.
Just for example, that was a main witness, and she admitted to watching YouTube. I'm concerned about witnesses watching YouTube. I'm concerned with potential jurors watching YouTube or asking friends or family to watch it for them. And so I'm just really concerned that Mr. Dillard won't get a fair trial with this being broadcast all over the internet.
All right. Now, and would you want the media excused as well?
Usually the media doesn't video record.
Yes, they do.
Out of when the jury's out of the courtroom. Like, for instance, like if there's a motion in limine and we're arguing about prior criminal record or something, the court grants it. I don't think the news cares about that. But if a juror were to see that, or a witness or one of the witness's friends, then they could let that slip out when the court has already ruled on that issue.
So you're okay with the media coming in filming, is that correct?
I don't have an objection to that.
Okay.
I don't have it to that. It's just broadcasting everything that happens in the case. The reasons that, and I will, in the motion on page 2, paragraph 5, I want to waive that paragraph because I do believe the court has changed the YouTube channel and does not allow chatting any further. And so I will waive that. I'm also concerned that there's an alleged victim who is a minor, and under the Texas Constitution, Article 1, Section 30A1, that person has a right to privacy.
Things just got serious. The alleged victim here is a minor. Under Texas law, that triggers strict privacy rules. Broadcasting this trial could expose sensitive details, so should the court pull the plug before the damage is done?
That by broadcasting it, her name will be revealed. And also, whenever the jury is picked, their names are called out loud, and that's supposed to be done secretly.
All right. Is there anything else with regards to your motion, counsel?
Well, the main focus is the concern for Mr. Dillard getting a fair trial based on only the evidence that is presented in court and not broadcast or archived videos of earlier proceedings that are watched by potential jurors and potential witnesses.
Okay.
And that's just too huge a risk.
All right. And this is your only pretrial motion?
No.
Just like that, motion denied. The live stream stays on. The defense sounded the alarm, but the judge didn't flinch. Now the trial unfolds before the entire internet, and the pressure has never been higher.
Vision be for a term of 5 years. Did you understand that was a recommendation from the state and the court does not have to follow that recommendation?
Yes, Your Honor.
Then to the lesser included offense, how do you plead? Guilty, not guilty, or no contest?
No contest, Your Honor.
State any evidence.
Yes, Your Honor. State offer states 1 and attachments.
Any objection?
No objection.
Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. The court has considered states exhibits 1 and attachments, which includes the stipulations. Is there any other evidence either side wish to present to the court before the court makes a ruling on sufficiency of the evidence?
Yes, Judge, Mr. Diller would like to make a brief statement.
All right. Yes, Mr. Diller.
Yes, Your Honor. I grabbed her arm.
All right. And I'm assuming the grabbing of the arm caused pain. Is that correct?
Yes.
All right. Is that yes?
Yes, Your Honor.
All right. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Yes, Judge, this is a life-changing incident. Mr. Diller also suffered from a very debilitating accident in 2019. Prior to the outcry, before the charges were filed, he was in a great relationship, and he's been frozen in fear about fighting this case, and he would do it if he had to. His plea agreement, we believe, is in the interest of all the parties. Mr. Diller will not have contact with the complainant in the future.
Okay. Are you employed?
No, Your Honor.
So how do you support yourself? Are you on SSI or something?
I filed for the, I got denied for the original one because I have too many resources available to me because of my wife's income. Now they're doing the disability part of it, and I think they're at 95% right now.
All right. All right. This is what the court is going to do. The court is going to sentence you to 6 years deferred adjudication. There's to be no contact with the complainant, proof of employment or SSI within 45 days. There's to be no employment as a home health care provider or with minors. There's to be no unsupervised contact with minors. Regular reporting.
The gavel falls, 6 years of deferred adjudication. No contact with minors, anger management, community service, and strict probation. The judge isn't showing mercy, he's testing discipline. One wrong move, and the court's second chance turns into a sentence.
By Zoom or in person. Regular random UAs. And due to your medical, are you on any type of medications?
Yes, Your Honor.
All right, you'll need to let probation know what those medications are, and you'll need to do a release from your doctor so they can make sure that those medications are being taken as prescribed. You understand? Bill visit 1 time per month for 3 months. 100 hours of community service restitution. If you would like, you can pay those off at $7.25 per hour. I always recommend the food bank because they always need help. But if there's another charity you would like to donate that to, just ask probation and they'll let you know if it's an approved charity.
Yes, Your Honor.
All right. Probation, and we'll do anger management. Probation, is there anything else? Okay. Is there anything else you need from the court to be successful? All right. I understand that you have some medical issues that may preclude you from employment. The court costs in this case is probably going to be around $385 to $400. So if there's a reason why you cannot pay that, just let probation know, and they'll have to do an indigency form for you to see if that's true and if it would be appropriate for that to be waived. Do you understand?
Yes.
Do you have any questions about anything?
No.
All right. We can go off the record. In this court, to be successful on probation, communication is key. If there's an issue, you need to let probation know about it. If you feel they're not addressing it, you can always come back